youths in East Africa, and then it's a big problem to secure jobs in East Africa. And then when you actually secure it, you're at risk of being mistreated by your employers because you do not know enough about your employment rights. So in this forum, we will discuss the employment laws that exist in Kenya, Uganda, and Tanzania to protect workers and provide valuable information to those that are seeking employment and to those that are already employed. I'll be hosting a team of 4, but I can't help but notice that one of us is not here yet. So I'll give the lawyers, because the lawyers are already on the forum, an opportunity to join and to tell us a little bit about themselves and why they feel that they're the best to have the conversation on employment laws in Kenya, Uganda, and Tanzania. I'll go ladies first. I'll start with Ruth Kanyanya. Hello, Ruth. Take a minute to tell us a little bit about yourself. Ruth? Ruth, we're having a little bit of problem hearing you. Could you fix your audio quality and then get back to us? So I'm going to give Judge an opportunity to introduce himself. Judge Bush.
Hello, good morning. My name is George Bush. I am an advocate of the High Court of Kenya. I work with an organization in Kisumu called Homeless of Kisumu, which offers psychosocial support and empowerment to street-connected youth, vulnerable women, and children. Some of our program areas include social protection, where we offer legal aid services, we offer family support services, we offer legal representation to people who cannot afford it, and general advocacy and awareness creation, especially in Kisumu. Thank you.
Perfect. Thank you for that breakdown, advocate of the High Court in Kenya. That is George Bush, who works with Homeless of Kisumu. And I think George Bush is the best person to to have the conversation on employment laws in Kenya, Uganda, and Tanzania, because I am pretty sure, has worked with youths all over Kenya. And he will be telling us a little bit about the issues that youths face on employment. Now, I don't know if Ruth has been able to fix her audio. Ruth? One more time, Ruth, please give us an introduction if your audio is fixed. It seems we can't get hold of Ruth. I assume she's still working on her audio quality. Well then, George Bush, advocate of the High Court in Kenya, you're going to start us off and you're going to give us an overview of the employment laws in Kenya, specifically when it comes to things regards grounds for termination, minimum wage, working hours, and leave entitlements. Judge Bush.
Hi, Ms. Karime. So I'll start with a brief overview of the legal framework of laws governing employment in Kenya. At the very basis of it, we have the Constitution of Kenya. Generally, the Constitution of Kenya is the overall law that governs every other law in Kenya. And in terms of employment, we have Article 41 of the Constitution, which provides every employee with the right to fair labor practices. This is the basis of all employment laws that are in Kenya. These include fair remuneration, reasonable working conditions, the right to form or join or participate in labor trade unions or organizations, to go on strike, and matters like that. We also have different articles of the Constitution which speak specifically to employers and employees' relationship. We have Article 25, which prohibits slavery and servitude. We understand that the employment is based on contracts, and contracts are based on free will. It is the intention of two parties to enter into a contract of employment. So there is no way one can force the other to enter into a contract of employment. That is prohibited. Article 27 of the Constitution prohibits discrimination, and we'll talk about this in depth. Article 36 of the Constitution of Kenya provides the freedom of association. This gives a right to employees to join trade unions and other associations. And it also provides a leeway for employers to form employers associations. Article 43 of the Constitution provides for social security. Now, we know that in Kenya we have the National Social Security Fund, which is an act coming out of this act to protect the pensions and contribution of pensions for employers and employees. We have Article 47, which provides the right to fair administrative action. This protects employees against uh, summary decisions made by employers which may otherwise hinder their productivity and their rights to employment. The Constitution also protects special groups such as people with disabilities, the minority groups, by providing a leeway for special opportunities. And this is termed the affirmative action. Article 55 and 56 provide youths and minorities with affirmative action programs, and it basically imposes a responsibility on the government to provide this. Article 162, whenever disputes arise, uh, there needs to be an avenue where these issues can be raised. So Article 162 of the Kenyan Constitution establishes the Employment and Labor Relations Court, which deals specifically with matters to do with employment disputes, matters of unfair termination of employment, poor working conditions, and even work injuries. Now, the most basic substantive law, I'd say, governing uh, employment in Kenya, I'd say, are contracts, the law of contracts. All employments are based on contracts, and basically these contracts can be oral or written. But now the substantive law governing employment in Kenya is the Employment Act, which came into force in 2007. And this act is guided by three basic major principles. First is the prohibition against forced labor, which, as we saw, takes us back to Article 25 and Article 30 of the Constitution, which prohibit forced labor and slavery. We have the second principle as discrimination, which takes us back to Article 27, the prohibition from discrimination. We have the third principle as sexual harassment, which has been an issue. The other day we saw a documentary by the BBC about the Finlay's tea farm in Kericho and how sexual harassment was a very, very rampant issue in that place. Now, under Section 4 of the Employment Act, it prohibits forced labor and does not include work done voluntarily. Forced labor, this is the work done that is not voluntary or work done under the threat of a penalty. Now, there are caveats to what constitutes forced labor. We know that work done by virtue of compulsory military service laws do not constitute forced labor. Work which maybe form part of the normal civic obligation of citizens do not constitute forced labor. We have work done as a consequence of conviction of law when someone gets sentenced, you may hear the judge saying you receive 5 years plus hard labor. This does not form part of forced labor. We have work that may be done during calamities or threat of disaster or war, such as peacekeeping, rescue services. These may not form part of forced labor. Section 5 of the Act requires employers to eliminate discrimination at work. And when you talk about discrimination, you're talking about very many forms of discrimination. There has been discrimination maybe on the basis of race, the sex of a person. We have had instances where women are discriminated against, marital status, pregnancy, disability, age. And when we talk about the challenges facing the youth, I'll talk about age as one of the main factors that, as a challenge in employment. We have the discrimination based on religion, based on conscience, based on belief and culture. Now, if we move away from that, uh, the Employment Act basically sets out different aspects of employment. It regulates the relationship between an employer and employee. It also provides for protection of wages. Now, we understand that there is no statutory minimum wage set that is universal to all sectors, but it differs from sector to sector. But all of that is protected by the Employment Act, where an employer does not have the right to reduce your wage without consulting you, without your consent. The only thing you can do ni kuirudisha is taking it back up. So it also sets out the rights and duties of both employers and employees in the employment contract, because we understand that the employment relationship is a contract. So when this contract is breached, there comes an issue. So the Employment Act sets out rights and duties. Some of these rights include basic minimum conditions for employment. They're different. This may differ depending on the sector in which someone works. There is the maximum working hours per week, which we know that statutorily the maximum working hours for between 6 days is 52 hours, and the maximum working hours for night shift people, it might be 60 hours. So these may not be contravened by the employers. The Act provides for annual leave, where we know that after someone has worked for a period of maybe an year, they are entitled to, at the minimum, 21 days annual leave with full pay. The Act also provides for maternity leave. Generally, it provides that for women during birth, they are entitled to 3 months maternity leave with full pay. And we know that this leave may also come in congruence with the annual leave. So a woman who has given birth can also add her annual leave to a maternity leave and will be entitled to full pay. We know that we have a new act which came into place. It is an amendment of this act which provides for pre-adoptive leave. So parents who are intend to adopt a child are entitled to a month's leave with full pay from the date on which the child has been assigned to them. We are also the act also provides for sick leave, where we know that a person is entitled to 7 days sick leave with full pay and an extra 7 days with half pay. The Act also provides for provisions such as housing allowances, water, food, good working conditions, and all of that. In addition, the Act provides for laws governing termination and dismissal. Basically, it provides that before that an employer has no right to dismiss someone without notice, and it depends on the type of contract that is in place between the employer and the employee. We know that for contracts that where the person is paid every 24 hours, there does not need to be notice. The notice can be given during the time when that person is paid. Maybe if the person gets paid in the evening of every day, at that evening the employer can say, tomorrow don't come back, there is no work tomorrow. Where the employment contract provides for payment after every month or 30 days, there needs to be a minimum of 28 days notice of termination. Where the contract provides maybe for a period that is less than a whole month, maybe let's say maybe a week or 2 weeks, the period of notice also needs to be in tandem with the period in which the person is paid. For example, if you're paid every 2 weeks, the notice needs to be a 2 weeks notice. If you are paid maybe weekly, the notice needs to be a 1 week notice. The act provides also for payment in lieu of notice, where an employer decides to terminate your employment status without notice. They are supposed to pay you wages in which are sufficient for that period that you would have worked if you would have been given notice. For example, if you are supposed to be given a whole month's notice, then you're supposed to be and you're terminated without that notice, you're supposed to be paid wages that are enough for that whole month. If you're paid 30,000 per month and you are terminated without notice, maybe without that 1 month's notice, the employer is supposed to pay you that 30,000 shillings for that month. And we know that there are also other instances in which an employer is also allowed to terminate without notice, and this is called summary dismissal. But there have to be sufficient grounds, for example, gross misconduct, and the employer will have the responsibility to show that this termination was rightful given the circumstances. The enforcement of this whenever there is a dispute in terms of summary dismissal, the major burden of proof is on the employer to show that it was justified. The Act also provides for avenues to, address unfair termination or reasons for termination. Basically, you're supposed to be given a chance to be heard. It is based on a rule of natural justice in law called audi alteram partem. Basically, it says an accused person must be heard. You cannot be convicted and heard. Basically, you're supposed to be given a chance, and this is why we have maybe disciplinary procedures and maybe notice. You're given a notice, and then you're told to come for a disciplinary hearing, and then you're being given dismissal. Basically, the Act also provides protection of children from unfair employment. It prohibits employment of children who are under the age of 13 years old, and for children between the ages of 13 to 18 to 17, that is, it provides that they may be employed under circumstances that do not breach their rights as children. For instance, access to education, access to good food and healthcare. The type of work that they are given should not be part of what is considered child labor. The Act basically talks about very, very many different aspects, some of which we'll talk about in depth during the question and answer session. But I'd like to just brush a bit more on the different other laws that also govern the employment in Kenya. We have the Labor Relations Act, which provides for the formation, for the registration of trade unions and employers associations and the relationships between them. We have the Labor Institutions Act, which provides for the creation of labor institutions. Basically, this one is mostly on the government side. We have the Occupational Health and Safety Act, which provides basic minimum standards of well-being for workers, which provides their health and safety during in the workplace. We have the Work Injury Benefits Act. Now, this is, in Kenya we call it the WIBA. This governs the remuneration of employees whenever they sustain injuries at the workplace. And this has come in at a very good time when there have been disputes, in jurisdiction between courts, between whether injuries that happen at work can be addressed by normal courts, and it has brought in a more flexible avenue for employees to receive their benefits. We have the Employment and Labor Relations Court Act, which establishment, the ELRC, which is now the general court, which has jurisdiction to address employment disputes and fair termination disputes between trade organizations, and any dispute that arises out of the employment contract will be addressed under the Employment and Labor Relations Court. And this gives effect to Article 162 of the Constitution, which provides that the parliament shall introduce an act that specifically deals with these disputes. We have the National Social Security Fund Act, which basically provides for guidelines relating to contributions for an employee's pension. We have the National Hospital Insurance Fund Act, which provides also guidelines for contributions for national health insurance for employees. We have the Data Protection Act, which is a new act that came in to protect data. It places an obligation on employers to use data given by clients, by employees, in a way that is legal, in a manner that protects their rights to privacy. And up to that, I think I'll log off and take it back to you, Ms. Karimi. Thank you.
Thank you very much, Bush. That was a very detailed breakdown of laws in Kenya that protect employers and employees in the workspace. You told us about the NSSF Act, the NHIF Act, the Data Protection Act. You also broke down to us the Employment Act of Kenya, and you put forward issues that I would like us to look into as we go on. And that overview was very well welcome. Thank you so much, George Bush, Advocate of the High Court, Kenya. Now, I want us to move to Uganda, and I want Ruth Kanyanya to come in and to tell us an overview of the laws in Uganda that protect employees and employers in the workspace. An overview just like the one Bush did would be very much welcome. Ruth, are we together?
Okay, yeah, thank you so much. I hope I'm audible
Okay.
now. Okay, so in Uganda, we have the Employment Act of 2006. So this is the governing act. It also has the regulations of the Employment Act Regulations 2011, and we also have the Occupational Health Act, which is also in charge of protecting employees and employers in Uganda. So on this, I would first of all want us to understand what is it, when they talk about employment, contracts, casual workers, what do these terms mean to us? So I'd like to interest us with the definition of an employee. An employee means a person or group of persons, including a company, corporation, public, regional, or a local authority, governing body. So it's like that body that employs someone. Then when we talk about an employee, who is an employee in the first place? An employee means any person who has entered into a contract of service or apprenticeship contract. So you as a person, when you enter into a contract with an employee, with an employer, you become an employee to that person. Then who is a casual employee? The laws of Uganda define the Employment Act defines an employee to mean a person who works on a daily or hourly basis, where payment of wages is due at the completion of each day's work. For example, these boys who collect plastic bottles, whenever they collect, they take to the person who has ordered them, to the employer who has ordered them to collect those bottles. At the end of the day, they are paid something. So those ones are termed casual workers, and they do not have contracts, because at the end of the work of the activity, they are given their salary or their wages at that moment. Then we have what we call a contract of service. A contract of service means any contract, whether oral or in writing, whether express or unimplied, where a person agrees in return for remuneration to work for an employee and includes a contract of apprenticeship. So when you get into that relationship, work relationship between you, an employer, and an employee. There is this contract of service that you sign. It's an employment contract that you sign between you and the person employing you. But this contract of service has caused a lot of issues in Uganda because most employees do not want to give their most employers do not want to give their employees this contract because of the legal consequences or anything. So they just want to make an oral contract, and which they do not even follow up later. And this has become a very big challenge to most youth in Uganda because this leaves a loophole where your boss can terminate or fire you at any time as they so wish. Then we have what we call wages. As an employee, as you work, you expect to get something at the end of the month or according to the terms you've agreed on. And that thing is called a wage. What does it mean? It means remuneration or earning, however designated or calculated, capable of being expressed in terms of money and fixed by mutual agreement or by national laws or regulations, which are payable under an oral or written contract of service for the work done or to be done, or for services rendered or to be rendered, but excluding any contributions made or to be made by the employer in respect of his or her employees, insurance, medical care, welfare, education, training, in retirement, pensions, all that gratuity. So that wage that you're given, some good companies, when you're working with them, they come with benefits. So those benefits are not part of of the wage they give you. They are like deductions. They deduct them away from your salary. Then they give you a certain fixed portion. But those benefits, for example, medical allowances, pensions, NSSF, all that benefits you as an employee in Uganda. Then Section 2 of the Employment Act defines a contract of service to mean any contract or express that had earlier on explained about it. Then Section 25 of the Employment Act provides that a contract of service other than a contract which is required by any act to be in writing and may be made orally. So as I had earlier given an example of how most employees do not want their contractors to sign these contracts, but the best way that I would tell every youth out there who is looking for employment, it's very paramount or very important for you in the first place when you're given that job or an appointment to have a contract signed, because it lays clearly the terms on which you're going to work on to avoid struggles or instances that will come in with firing and hiring you. That will be easy. So, and Section 10 of the Contract Act in Uganda, it's an act of 2010, whose subject matter, they said that if you, in a contract of employment, as long as it exceeds 500,000 shillings, Ugandan shillings, you're supposed to have a written contract to that effect. Then, after taking you all that employee and knowing who is an employer, an employee, casual workers, the remuneration, the wages and all that, and the contract of service, yes. Now we shall look at the rights of the employees in Uganda here. Basing on the Employment Act, there are certain rights that are provided that are meant to protect us, the employees. First of all, what do we understand when someone says that it's a right? A right is a power or a privilege held by the general public as a result of the Constitution, statute, regulation, judicial precedent, or other type of law. Or it is a legal enforcement claim held by someone as a result of specific events or transactions, or something a person has which people think should not be taken away. So it is that claim or that legal enforcement that you have that you think that shouldn't be taken advantage of or shouldn't not be followed. That is what we call a right, something that you protect or the laws protect. So the rights some of the rights that are provided under the Employment Act of Uganda are right to weekly rest. Like if you've worked for the days you're meant to work, at least there should be a day that if an employer gives you to rest as an employee for effective performance. Then the other right, this right is subject to an exception, maybe unless you run you're the manager of the company, or you're the person who is in charge of the daily activities. There you can, it's an exception to this effect, but other employees are entitled at least to a daily rest. Then we have a right to work for 48 hours per week. That is Section 53 of the Employment Act, that you're supposed to not exceed 48 hours as an employee. Then we have a right to annual leave and public holiday. That is Section 54 of the Employment Act, where these employees have to respect the public holidays and also to give the employees right to annual leave. Then we have the right to organize themselves into a labor union. That is Section 3 of the Labor Unions Act 2006 in Uganda, that encourages employees to engage in labor unions for effective collective bargaining and to have a fair representation in case of anything. So we also have a right to healthy and safety working environment. That is Section 47 of the Occupational Health and Safety Act, where workers are entitled to a clean, well-ventilated property, light and spacious environment, that they have effective and suitable systems for securing and maintaining the circulation of air. But when we look at some places, not most, but some places that employ the youth in Uganda, you find that most the youth who are working in these in other activities, you find the way where they sleep, the working space is not well ventilated. All this is a risk to a youth's health who is working in such kind of an environment, and yet the law is here to say that they have to work in in health and clean environment. Then when we look at the right to adequate sanitary convenience, that is Section 49 of the Occupational and Health Safety Act, you find most places, for example, working in a place, you're sharing washrooms. You, the female, you're sharing with a male, and yet the law is clear about that, the right to adequate sanitary conveniences. By the time you're sharing, that means they're not enough. In other words, women or ladies are entitled to have their own places of conveniency, and the men also are entitled to have their own places of conveniency, not to bring up that mix. And then we also have a right to payment. That is Section 87 of the Employment Act, that an employer shall pay severance allowance where the employee has been in his or her continuous service for a period of months or a month or more, and where any of the following situations apply, the employee is unfairly dismissed by an employer. So you as an employer, you are entitled, you are supposed to pay the employee their payment. As long as they have worked for you for a period of a month or months, you have to pay them. But this is what we see that has come as a challenge to most youth or most employees in Uganda here. You find you've worked, a month has passed, you've not received any wage. So, or you've not gotten any allowance that will sustain you in the course of your work. That is very unfair to most African youth in the world or here in East Africa. And that is a challenge to be addressed. And enforcement of these laws should be put so that we can realize the intention of these laws as to why they were formed. Then we have a right to rest. That is Section 51 of the Employment Act, that provides that we have, as employees, we are entitled to rest. But you find most youth are really overworked in East Africa, in Uganda. You work like day and night, like you really work a lot. So this is also something that we need to look into so that people can rest. Then we have right entitlement to a written contract. As a youth, as you're getting into the employment world, one thing I can beseech you is you are entitled to that contract. Do not fear to ask for it. Ask for it. So some people say, if I ask for that contract, they might fire me or what. But you are entitled to that contract under Regulation 39(1) and 2 of the Employment Regulations of Uganda 2011. So we shall look at that other bit of termination. Section 2 of the Employment Act defines termination of employment to mean a discharge of an employee from an employment of the initiative of an employer for justifiable reasons. So this means that before you are fired from your employment place, the employer has to give you justifiable reasons as to why they are firing you. And this, for example, the reason why you can get fired could be maybe you've done something that is contrary to your contract of service that is signed, and also Section 71 of the Employment Act 2006 goes ahead to emphasize this law that employees should give reasons to avoid circumstances of unfair termination. And then Section 65 of the Employment Act provides that termination shall be deemed to take place in the following instances: where the contract of service expires, or where the contract of service expires on the completion of a specified task. So if your time of service expires, there they can terminate you. Or if you do anything contrary to your contract, there they can give you reasons for termination. However, there is also a notice. An employee cannot just wake up one day and fire you without giving you prior notice before they fire you. So the law in the case of Bank of Uganda versus Betty Tinkamanya, it's a Supreme Court case. In this case, court emphasized that an employee should give reasons to the employer and notice before they terminate them, or they can even give you payment in lieu before they terminate you, meaning that if you're remaining like with 3 months to complete your contract, or some time for your contract of service to come to an end, and maybe they want to fire, they can pay you for those remaining 3 months to your completion of your contract, and then they terminate your contract on that ground. So what are the remedies as you, as a youth or an employee out there in Africa? What remedies do you have in case you are terminated? We have one. You can present a complaint to the labor officer, that is under Section 70 of the Employment Act, that an employee who complains dismissal without justification may present a complaint to the labor officer, who shall seek to settle the matter in the first instance by mediation. Then Section 70 subsection 4 provides that the right of the employer to present a complaint shall be in addition to his or her right or complaint of unfair dismissal or any other infringement of rights. So you have a right to write a complaint, take it to the labor officer, state you were either dismissed summarily or unfairly. You state the reasons as to why you were dismissed or why you're dissatisfied with a dismissal. Or if all that fails, you can lodge a complaint to court for unfair dismissal. That is Section 71(5) of the East African of the Employment Act 2006. If court finds the dismissal unfair, the court might give the following orders: order the employee to reinstate the employee. That means they bring you back to your workplace. Or order the employee to pay compensation, or they can compensate you for all the damages that you feel you have suffered, or obtain severance allowances. Yes, that is how those are the laws in Uganda that govern employment, and those are the laws that we keep on referring to in case of any issues arising. Thank you so much for listening.
Okay, thank you very much, Ruth Kanyana. I'm seeing from some of the comments that we're getting that people are learning a lot. Melissa Karemi is saying great topic, especially for those who do not have low backgrounds. And I have to agree with Melissa. I have learned so much from Ruth and George Bush regarding the laws on employment in Kenya and in Uganda. And I also want to add Lynette to the stream. She just joined us a few minutes ago. Lynette, because you just joined us, you're going to do a quick introduction. You're going to tell us a little bit about yourself. And then you're going to give us a quick, let me emphasize on the word quick overview on employment laws in Uganda, especially the ones that you feel are specific to the youths and affect the youths firsthand. And then we're going to continue from there on. So, Lynette.
All right. Hopefully, I'm clear enough. My name is Lynette Murunji, and I'm the operations lead at the Smart Youth Network Initiative. Apologies for coming in much later. I had issues with technology. I'm a young person, and sometimes keeping up is important when you get these opportunities. The organization I work with is called the Smart Youth Network Initiative, and it's a youth-led network organization focused on community transformation through capacity building of youth towards sustainable development in the domains of human capital development, which is why we are here. I was lucky that I have a lawyer friend who actually took me through some of the laws in my country, and much I honor our other guests, especially the lawyers that have just spoken before me. At least I know it's not just jargon. But as a young person, in summary, what the aspects of termination and all, I could just highlight maybe a few things in the aspect of young people. As young people, we are mostly taken advantage of because we're of what the law says, or our obligations, and also the obligations of our employers. And this has issues to do with how much money we are getting paid, because you're straight from school and you don't have experience, so they're usually paying you less than people who have experience in your field. And this brings into light the minimum wage, and also how to fight for your rights in case they're being violated at your workplace, when to ask for help, and also just merely being able to get a notice of saying if they're going to terminate your contract or if they're going to fire you. Usually, because you're young, sometimes they don't even give you like notice on that, like that one will just go. Besides, they don't even know. And I think I'll just touch on what my colleagues have not yet touched before, or maybe perhaps I missed it. That's on the minimum wage. I've worked before earlier on in my entry into the employment world. I worked in what you'd say within the night economy for a place where you're supposed to work between 8 to 9 hours. I found myself working 17 hours to the max because we were few, and there is that aspect of profit maximization. Usually I did human resource management, and much as they say it's to mediate between the employees and the employers, I believe personally most of it's just to protect the employer and also to keep the employee motivated enough to work and not overwork. Maybe you could, should I continue?
Yeah, please continue. I just wanted to smile at what you're saying live. Yes.
All right. So let me break down the minimum wages. Data on the internet. I didn't do any specific research or do like any surveys to ask people around. So feel free to correct me in case I blundered. The lawyers are available in case I've blundered. So in Uganda, minimum wage is 130,000 Ugandan shillings. That's about 35 US dollars. And in Kenya, the minimum wage is 1,500 and 120 Kenyan shillings. That's about 116, 117 US dollars. Then in Tanzania, it's 150,000 Tanzanian shillings. That's about 64 US dollars. Dollar, $1. And in Congo, Congolese francs, that's about 7,075. That's about $4 US. So with this comparison of the minimum wage in the East African community, we have Kenya ranking as first as the one with the highest minimum wage, followed by Tanzania, and then Uganda comes in third, with Congo coming in fourth and Rwanda coming in fifth. Burundi and South Sudan do not have a set mandatory minimum wage according to the law. So where does this place us? Because we have people who are working, for example, in depending on how much work you're doing. Imagine you're going to work on a daily, you have to spend transport, you have to eat food and all that, and even like the work you put in, this is not proper compensation for you. So even this minimum wage per month, it's for people who are like working like 5 at most days in the whole month, and the rest of the month is done and dead. But because the people do not have education qualifications and all that, so you find that they're being taken advantage of. But still, with this economy, you still need to be able to work and to get bread so you can move on with life. So basically, if you're considering your options, it's better to work for less than actually be unemployed at all. It's with these policymakers, and they're thinking of introducing the night economy. But even with the day economy, where people are only working during the day, a lot of exploitation is happening, especially exploitation. Because imagine you have a parent who has like a shop or an industry or a company, and you're their child. So technically, all you're doing is just seated there doing paperwork. According to the law, it's legal. You're not even supposed to work. You're not supposed to work between 7 p.m. and 7 a.m. if you're a minor. And a minor, according to the law, is anybody below 16. 16 you can work, 16 and above you can work, but under supervision of an adult. Either way, you're still not allowed to work between 7 p.m. and 7 a.m. But you find the children are working even on the streets. When you're walking on the streets, you find children in baskets to make money. Or that are in charge of them and actually monitoring them, and they have like key performance indicators or targets to meet. Imagine you're a child like supposed to be in school and all that, but sometimes they miss school, especially in the rural areas. They miss school because they have to go out and work and get money. So we don't really have like teams on grounds to monitor this. And also the other issue maybe in the exploitation is especially for these industries where the services are 24/7. So you find a person who's getting like 250,000, between 250,000 and 400,000. You find that this person is going to have to be at work from around 7 a.m. to 11 p.m. because because probably it's a supermarket or it's a restaurant or it's a fuel station. And sometimes these employers are hesitant to introduce shifts because they want to reduce on expenses to do with paying people and all that, and also provision of these other benefits like health, medical allowance, food, and all that. Maybe say for the industries where they're more exposed to harm, for example, in the construction industry. I won't disclose the company, but I have a friend who injured their finger, and they were saying that the employers said they don't have money, so you have to get your little money that they're giving you and you buy yourself gear, but not everyone is going to be able to do so. And 20 years down the road, you have a missing finger simply because you just wanted to work. And that's how you're going to live your life, because you now have a missing finger simply because an employer did not give you work gear to while you're operating machinery. But that's just a TD needy.
Linus, I think we're going to continue because we lost you at that last point. Let's just move on. So that was a very wonderful breakdown from Lynette, and particularly because she was very personal in her examples. She said this is what happens on the ground. And using what Lynette said and using other stories that we've gotten throughout the employment laws in Kenya, Uganda, and Tanzania campaign that we have been doing prior to this on our social media platforms at Speak Up Africa, Africa with a K, I want us to look into some issues that have been brought forward, what I will be calling this segment as the frequently asked questions. So Ruth mentioned something in light to oral contracts. She said that employers nowadays have become very, well, how do I say, dubious. They have become, they don't want to give us contracts, written contracts, but oral contracts are given. You're told this is what we will pay you, this is what we will do, this and it's given to you orally. Is there a way that you can use an oral contract to defend your job on when termination is knocking on your door? So I want us to answer this in one statement or so. George Bush, you go first. Tell us, are oral contracts valid, and how can you prove that you were given an oral contract?
Okay, basically, oral contracts are valid, yes, but under the Employment Act in Kenya, contracts that are meant to go past 90 days, that is 3 months, are supposed to be in writing. So whenever you are employed on an oral contract, your employer has the responsibility to give you a written contract within 90 days. And where it is an oral contract, we can have, and a dispute arises, there can be proof of payment can be used. Now we'll find that most payments are made maybe through bank transactions or M-Pesa transactions. So this proof of payment or any proof of engagement between you and the other person can be used as evidence of an oral contract. We know that contracts of employment are basically some of the only contracts that do not really require witnesses for them to be effective. So any evidence of dealings between you and the other person can be used as proof of contract. I have a case where a senior advocate employed a junior who is my colleague and under an oral contract, and terminated his contract within a month, like 2 days to the day when he was supposed to pay his salary, decided to terminate his contract through WhatsApp messaging. So you see, whenever there is proof of engagement, even our WhatsApp messages, anything that can be shown that we had engagement with this person can be shown as a proof of oral contract. Thank you.
Thank you so much for that, Bush. I didn't know that even WhatsApp messages are proofs of oral contracts. Well, the employers, you've had that if you've given your employee an oral contract, within 90 days, you're supposed to give it in writing. And anything, any WhatsApp messages, any bank transactions can be used as grounds to show engagement between you and your employer and vice versa. Now, the next frequently asked question, and this one is going to go to Ruth, is can your employment be terminated on grounds of intoxication at the workplace? We've gotten this question numerous times. So Ruth, what do you tell us? Can you have your job gone because you're intoxicated at the workplace?
Okay, thank you so much for that good question. Intoxication, when you're entering into a contract of service with a person, it has clauses, different clauses. So if there's a clause that prohibits intoxication in that contract, says that you're not supposed to drink at your place of work, or you're not supposed to work under the influence of alcohol or intoxication, if it is well clearly stated in that contract, or if it is in the company policy that you're not supposed to drink or get intoxicated at a place of work, and you go ahead and go contrary to that clause or to that policy that you found in the company where you're working at, then you can be terminated from your workplace. I think that's
okay. So says if there's a clause or an understanding between you and your employer that you're not supposed to be intoxicated in the workplace, then the employment can be terminated. So here's a question. If there's no clause on intoxication in your contract, and if you're intoxicated but you still fulfill the mandates of your job and you are wholly capable of finishing your duties and you actually finish them, should your contract be terminated? And I'm going to give this to Bush. Tell us, do you think your contract should be terminated if you're intoxicated in the workplace and you still fulfill your duties?
Okay, basically, under the Employment Act, you cannot be terminated for intoxication unless the situation of you being intoxicated renders you incapable or unwilling to perform your duties under that contract. As for adding to what Ruth said, if the company has that policy, then you can be terminated. But if it is not there, provided if you can still work, you're intoxicated, but you can still work and fulfill your tasks as required, then your employer may have no grounds to terminate you unless it is a policy, maybe it is a breach of gross misconduct or something. But this should not be used as an excuse by employees to get drunk, saying that they can still do their work. Thank you.
Okay, so Bush and Ruth have both said, please don't get intoxicated in the workplace, but it is true that your contract cannot get terminated or your employment cannot get terminated because of intoxication, unless, to quote Ruth's words, it is a clause, there's a clause in the contract, and also to quote Bush, if there's no clause in the contract or there's no policy within the company, if you do not do your job, that is grounds for termination. Another one, and this one I want to give to Lynette. I don't know if Lynette is still with us. I want to give this to Lynette. What qualifies as minimum wage? At what point do we say this is the minimum wage? Is it the amount of money that is paid to the majority of the people? Is it the average amount of money that's paid to the majority of people? And does minimum wage vary from one person to another? Does minimum wage also vary from one sector to another? Lynette?
I think Karine, you're kind of breaking up. I think I have an issue with my network. Please kindly ask your question. The question on I had you calling for me.
I'm sorry, I thought you had me. I asked what qualifies as minimum wage. What is the qualification of minimum wage? Is it the amount of money that is paid to the majority of people? Is it the minimum amount of money that is paid to the majority of people? And does it vary from one person to the other? And does it vary from one sector to the other?
Yes, I think for an industry where people are also voluntarily unemployed, like they, and also sometimes they choose to work for free. That means from even from industry, tells me that in the whole day that doing like is the minimum wage as somebody who probably just like and watches YouTube videos says it's neutral out there. I believe that our companies, we have very talented individuals. They've come up with something that by law in wage is 130,000. I'm going, if I'm an employer, perhaps I'm going to give a person, say, transport allowance, lunch allowance, even probably give them even housing too. So that much as I'm only obligated to give them minimum 130,000, but because of the kind of work that they're doing, I'm going to put in place these incentives like them getting proper medical care, that when they get the 130,000, they're not going to spend all of it in trying to cater for transport. Let's just being able to come back to work. And also, minimum wage can vary because sometimes even your qualifications determine how much or how little you're going to get, because even with profession, say perhaps doctors, I'm just giving an doctors can have assuming doctors had a minimum wage of like say 2.5 million, and then pharmacists had like a minimum wage of 1.5 million, and then like secretaries had like a minimum wage of 1.2 million, and then like say the president has a minimum wage of like, let me put 2 million. I don't know how much our president earns. So assuming it's like that, and this is like the minimum wage in all these situations. By law, they're supposed to get only 130,000, but some medical profession or in the medical world, the minimum a question, and also start to the fact that men and there is that Nova enjoyed because he's the favorite character, because as like have money, they have everything going on, but of course money can never satisfy until it comes to an end.
Right, so I think there was a little bit of breakdown from your end, Linus, but I think basically what you said is different sectors have different minimum wages. So you should identify your sector so you can identify what is the minimum amount of money that people are getting paid in your sector. Now, there are questions that have been put on the comment sections of our live, and one particular one is from John Miner. He says, as an employee, do our contracts need to be approved by a lawyer before committing to the job? And I want Bush and Ruth to answer this question for us. Do they have to be approved by a lawyer, or is this just something that you can do in-house without necessarily asking for a lawyer's help? Bush, how about you go first and give us an answer to that?
Generally, they do not have to be approved by a lawyer, but it is advised that you get a lawyer's opinion before you sign your contract of employment. but it is not a requirement that they be approved by a lawyer.
Okay, Ruth, how about you tell us, is it necessary for a lawyer to be there when a work contract is being set up?
No, it's not a must that a lawyer has to be there to witness. But however, if you deem fit that you want your contract to be witnessed by a lawyer, you can go ahead and do it. But all you can do is get that contract written on the mutual agreement of how you've agreed with your employer, have it, keep it. In case issues arise to the contrary of that contract, you can get it, present it as evidence to the lawyer that you've hired at that time to defend you or to make your rights to be fulfilled in regards to that contract of service, but it's not a must.
Okay. Thank you, Bush. Thank you, Ruth, and thank you to everyone that has participated in the conversation today. So today we were talking about employment laws in Kenya, Uganda, and Tanzania. We have so many questions that are going on. We have very many frequently asked questions, but I feel like they have been answered in the previous section where they were giving us an overview of the employment laws in East Africa in general. Now, I don't want us to go beyond the time that we have because we've already surpassed 5 minutes past the time we had set for this live. But if you have any questions regarding employment laws in Kenya, Uganda, and Tanzania, please make a point to leave it at the comment, and we'll get back to you through online engagements on Twitter, LinkedIn, and on YouTube, where this live will be airing. As we wind up, I want to give the panelists 1 minute to tell us what happens if all of these laws, all of these benefits and rights of the employees are not, they're not valued. What happens if the employer decides to terminate your contract before time? What happens if there's sexual harassment at the workplace? What do you do? What is this next step after? So I am going to start with George Bush. Bush, tell us what happens after. What happens if your laws and your rights are not respected? What happens?
Okay, so basically, first, I would like to point out that employers are obligated under law to put in a very conspicuous place in the office notice of the rights for the employees. And it is your right. If your employer does not have a notice on the notice where everyone can see it showing what your rights are, then he's breaking the law. But generally, where a dispute arises in Kenya right now, we have the Employment and Labor Relations Court, where you have found maybe there is an unfair dismissal. You can proceed to court. There is very flexible mechanisms. The matters proceed very fast, especially for employment, because those are the only matters that the Employment and Labor Relations Court address. In case there is sexual harassment, I know companies have HR policies and policies against sexual harassment, where one can report, and where it is reported and nothing has been done, I think it's advisable that we report to our maybe representatives in trade unions and maybe welfare. We have welfare offices in the office, and where these are not addressed, it is always good to now upscale it to the court. You know, the first thing we always try to impress on alternative dispute resolution mechanisms. So you have to start at the bottom, then you proceed to the court, see if that conflict has not been addressed. But where you have been wrongfully terminated, you can institute a claim for wrongful termination, where you can be entitled to damages for wrongful termination, maybe compensation for the time that you would have worked, maybe breach of contract. There are so many avenues that exist right now that someone may use to address disputes arising due to employment. Thank you.
Okay, that was wonderful, Bush. Bush has said you can go to court, and he has also said that the employer should have your notice, they should have rights of the employees put forward. If they're not doing that, they're breaking the law, according to Bush. Now, Ruth, how about you tell us an overview. What happens if the rights are not respected? All of these rights that you broke down for us. What happens in Uganda?
Thank you so much. So in Uganda, under the employment sector, in case you feel like your rights are being infringed on, or you've been unfairly terminated, you can lodge a complaint to the labor officer. So the labor officer will get a day, will allocate a day or select a day for where you will come for mediation. So under mediation, you air out those rights that are being infringed, or the dispute that you're having, or something that you're not happy with in relation to your employment. So if you feel you're not complaint to court, and when you lodge the complaint to court, court will hear the matter. After analyzing, evaluating all the evidence and the facts at hand, they will either order your employer to reinstate you, or they can even order an employer to compensate you for the losses that you have suffered and all the other things, the damages that you have suffered. Yeah, that is what is done in Uganda. Thank you.
Okay. Thank you so much, Ruth. I want us to wind it up at that note. Thank you so much, Lynette Murugi, George Bush, and Ruth Kanyanya for joining us on this conversation. They have given us very nice information when it comes to employment laws in Kenya and Uganda. Apologies on behalf of our Tanzanian representative. She was not able to make it today. But next time we will have the whole conversation and include Tanzania in the whole conversation as well. We'll look into the laws that govern employment in Tanzania as well. But this will only happen if you ask us those questions so that we can have the time to give you back those answers. Right there on the comment box on our social media platforms, ask any questions in relation to employment laws in East Africa. My name is Wangeshi Karemi. This was Understanding Employment Laws in East Africa, particularly Kenya, Uganda, and Tanzania, with specific interest because we've done Kenya and Uganda only. I will see you next time. And on that note, let's end our broadcast.